Welcome again to the Melling Law YouTube channel, where we're talking about different estate planning topics relevant to people living in Utah. Today we're continuing this series about estate planning fails, things that people do with estate planning on a friend's advice or radio pundit's advice or an attorney who does not specialize and where they got bad advice. Whatever this may be, people do things that do not have their intended effect. And one of those is with Medicaid planning or Medicaid clawback. It's very common for people to be concerned about Medicaid. And this is with healthcare as a senior, you are entitled to Medicare, and that's, you've been paying into that system your whole life, and Medicare is part of that Social Security program. And so you're going to get your Social Security for income, you're going to get Medicare for your healthcare, and there are things that Medicare covers. And then there are things that Medicare does not cover, but if your assets are low enough in value, you can qualify for Medicaid to supplement the Medicare. Medicaid is interesting because it's a needs-based program, so there are some assets that are exempt as far as qualifying. So like your house, it does not count as an asset if you're trying to qualify for Medicaid, but your assets other than the exempt assets, so this is like money in the bank account, cash, things like that, need to be generally under about $2,000 to qualify for Medicaid. So it is for people who truly have nothing. And then Medicaid will help cover things like certain long-term care expenses and a few other types of expenses. Where this comes in with asset protection and estate planning is a lot of people want to be able to qualify for Medicaid, but they also want to be able to transfer their wealth to their children without worrying about clawback. Now, clawback or Medicaid recovery is when the state, for anyone who's received Medicaid funds, now this is not Medicare, this is Medicaid, the needs-based program. Anyone who's received Medicaid funds in Utah over the age of 55, the state keeps a tally of how much of those funds were used. And then when that person passes away, they can recover against their estate to up to that amount to be able to reimburse the state for those expenses. So that includes the house and a few other things, with a few exceptions that we won't go into in this video. That clawback is what a lot of people are worried about, especially people who have like family farms and or a house that's been paid off that they want to go to their children. The problem though is that the state wants its money back. So how do we protect from that? And a lot of people will try to transfer assets to their children as a way to avoid this. So one of the major fails is that they'll make this transfer to impoverish themselves. So they have, let's say, a net worth of $2 million. They transfer all their assets to their children, and then they try to apply for Medicaid the next month because now their assets are under $2,000. And the state does not like that. So as of now, in 2017, the state goes back 5 years, and they look for any gifts, any sales, not any transfer that is not for fair market value. So even if you sold your house for $10,000, they're probably not going to count that. They're probably going to see that as a gift. And what they'll do is they'll void that transfer. So then they go after the people you transferred those funds to or those assets to, and they want those people to reimburse you or void that transaction so that it reverts back to you so that you have those funds. And if you spend those down over a period and then in the future apply for Medicaid again, you could qualify. But these types of transfers, they don't work. You can't just transfer all your assets and then the next month apply for Medicaid thinking that you're going to qualify and not be subject to some kind of clawback or recovery. So what some people will do instead is they'll transfer all their assets and then have their children support them for 5 years and then apply for Medicaid. One of the problems here though is that these assets, you can have no retained interest in this. So let's say you transfer your assets to a trust, but you still have authority to be able to receive income from this trust. You have the ability to control this trust in any way. but then after your death, it would go to your children. Even then, these trusts don't hold up anymore according to state Medicaid rules, because you retained a benefit from the trust and you retained some kind of management interest in the trust. So there are a lot of, Medicaid is a very complex issue, but what we're trying to get at today is that a lot of people try to make transfers because they're worried about Medicaid recovery, but they don't think about all of the implications of the transfer. And in addition to the tax disadvantages and a few other disadvantages of making these types of transfers without a professional's help, frankly, they just don't even have the intended effect. If the sole reason for making these transfers is applying for Medicaid without being subject to clawback, and then you end up being subject to clawback anyway, there's no point in going through all this hassle. So if you're making Medicaid, any kind of Medicaid planning, you want a professional's help to make sure it's done correctly and that you're advised of all the consequences, positive and negative, of any type of transfer. So thanks for watching. If you have any other questions about estate planning here in Utah, feel free to give us a call or reach out on our website.